Hi, thanks for visiting worklawyer.ca. I'm Jeff Robles, a certified specialist in civil litigation and a partner with the law firm of Riley and Partners in Ajax. So, the topic that I wanted to talk about today is secret recordings. And sometimes I'm asked by clients whether it's illegal to secretly record discussions that occur in the workplace. And when faced with that question, I usually respond that secret recordings can indeed be illegal depending on circumstances. Let's take a look at Section 184, subsection 1 of the Criminal Code. And that states every person who, by means of any electromagnetic, acoustic, mechanical, or other device, knowingly intercepts a private communication is guilty of A, an indictable offense, liable to imprisonment for a term of not more than 5 years, or B, an offense punishable on summary conviction. Now, the key word in this section is private. If the person is actively involved in the discussion, then the communication isn't considered private and the act of recording would not be illegal. However, just because it's not illegal to secretly record a workplace discussion that one is participating in doesn't automatically mean that it would be a good idea to do so for the purposes of a wrongful dismissal case. I want to talk about a couple of cases that provide a contrast as to how these kind of recordings can be received in court. Let's start with the decision in Telger and Aurora Hotel Group, a 2023 decision of the Ontario Superior Court of Justice that was upheld by the Court of Appeal. And now this case is an example where the plaintiff employee relied upon a secret recording as evidence without any adverse consequences. The plaintiff in this case held the position of general manager with the defendant employer. And then after 3 years of service, the defendant company dismissed the plaintiff on a without cause basis. During the termination meeting, the plaintiff employee secretly recorded discussions between him and the senior executives who handled the termination meeting. The plaintiff later sought to rely upon that recording in his wrongful dismissal action. The judge who heard the plaintiff's summary judgment motion requested a transcript of that recording. The motions judge not only considered this evidence admissible, but even gave considerable weight to it in determining the issue of mitigation and the claim for moral damages. Now, on the other hand, the decision in Shaligan and Mercer Selgar Limited Partnership, a 2023 decision of the BC Court of Appeal, is a case where the plaintiff's use of secret recordings in support of a wrongful dismissal action actually backfired on him. A few years into the plaintiff's employment, he began recording discussions with the defendant's management with a view to trying to protect his rights at work. After the company received an email from the plaintiff wherein he threatened the possibility of litigation following an unfavorable performance review and a refusal to award him a discretionary bonus, the defendant company decided to let him go on a without cause basis. At the trial of this action, the court concluded that the plaintiff's secret recordings constituted after acquired cause for dismissal that went to the very root of the employment contract. It ruptured the working relationship and broke the mutual trust between the parties. The large volume of recordings involved made other employees feel violated and breached the defendant's code of conduct that required the employee, to act with honesty and integrity. And so as a result, the court concluded that the defendant company had justification to dismiss the plaintiff for cause, despite originally doing so without cause. The BC Court of Appeal saw no basis to overturn the decision, and at this point, I don't know whether it's going to be appealed to the Supreme Court of Canada. So as a takeaway from these cases, while secret recordings of conversations at work can potentially serve as useful evidence in a wrongful dismissal action, they can just as easily serve as after acquired cause for dismissal. From a tactical perspective, under Rule 30.02 of the Rules of Civil Procedure, these kind of recordings could be considered relevant and therefore subject to disclosure, production, and even inspection. If the employee made the recording simply to protect his interests at work, as in the case of Mr. Shaligan in the second case that we talked about, and not necessarily in contemplation of litigation, then privilege may not attach to it and therefore has to be produced. A failure to disclose the recording in the affidavit of documents could have the result of trial by ambush and possibly invite the adverse consequences as set out in Rule 30.08 of the Rules of Civil Procedure, which include the possibility of the court not allowing that recording to be relied upon at trial. And if an order is made under Rule 30.02 that we talked about earlier, could potentially have the result of having the action dismissed. So in summary, while it might seem like a good idea in the heat of the moment, employees should think very carefully before pressing that record button in the workplace. So that's the episode. If you enjoyed this episode, please be sure to like and share and follow on Facebook, Twitter, and YouTube. And wherever you listen to your favorite podcasts, Spotify, Google Podcasts, Apple Podcasts, and Amazon Music. Thanks again for taking the time to visit today, and we'll see you next time.